together today's session. I'd like to thank our VP of Programming, Allison Green, our president, and our amazing panelists who Janae will introduce shortly. But before that, I just have a quick housekeeping matter. There are some of you who are interested in getting CLE today. So please, right now, put your name in the chat to the host. And throughout the program, you will hear CLE words. You will need to send that word and the timestamp to the host when you hear the word within 20 seconds of doing so. Okay, so you will hear the keyword, you will send the word and the timestamp to the host, and Zoom will record that participation. At the end of the program, you will sign out. You will send your name to the host, which will indicate that you are leaving at the time that the program ends. So just pay attention to the keywords, which Janae will incorporate into her presentation. And the first word is cat, C-A-T, cat. A Maine Coon is a large North American cat. You have 20 seconds. All right. And with that, I have the privilege of introducing our moderator today, Janae Thomas. Janae is a graduate of Florida State University, where she graduated magna cum laude and completed the Degree in 3 program. She then went on to receive her master's in business administration and her JD from the University of Florida in 2013. She's currently an assistant state's attorney at the Office of the State Attorney for the 13th Judicial District as an assistant state's attorney, where she has practiced for 5 years. Her work has inspired her interest in criminal justice reform and policy, and she is currently, can you believe it, pursuing a PhD in government in the School of Interdisciplinary Global Studies at the University of South Florida. And in fact, she had an exam this morning, so the MVP for today is Janae. Thank you so much. Despite all of this, Janae volunteers approximately 30 hours per month with various organizations, including as a co-chair of the Hillsborough County Bar Association's Community Service Committee and chair of the State Attorney's Speakers Bureau. In addition, she serves on the Leadership Council for Big Brothers and Big Sisters of Tampa Bay. And with that, I present to you our moderator for today. Janae, it is all yours.
Hi, everyone. Thank you for that introduction, Bianca. I am Janae Thomas, and I am an assistant state attorney here in Hillsborough County, where Andrew Warren, who is one of the panelists, is our state attorney. I am going to briefly introduce the panelists. All of this will be provided to you later in the program or afterwards. Their bios are so long that we could spend an entire program going over them. So I'm just going to introduce them very briefly. Just know that all of our panelists are extremely well qualified and all have been practicing for 10 years or more, and some of them more than 30. So with that, I'm going to go in alphabetical order and just briefly introduce our panelists. First, we have Elise Constantine. She is a federal prosecutor in Washington, D.C., where she has been practicing since 2015 and serves as the Deputy Chief of Early Case Assessment Section. Next, we have Christine Soto-Duberry. She is located in California, and she's an attorney and policy strategist, where she has been working for over 20 years, implementing various forms of criminal justice reform. So this is one of her specialty areas. Next, we have Mr. Grace. Bobby Grace is a prosecutor in Los Angeles County, where he has been serving for over 32 years. And he joined in the fall of 1988. And prior to doing that, he attended UCLA for his undergraduate. And next, we have Mr. Gurria. Charles Gurria is an assistant district attorney in Kings County, New York, where he has been serving for the last 30 years. His job duties currently include the prosecution of complex felony fraud cases, including enterprise corruption, healthcare fraud, and other fraud cases. And finally, we have Mr. Andrew Warren, who is the state attorney here in the 13th Judicial Circuit, Hillsborough County, where he has been serving since 2016. Prior to that, he served as a federal prosecutor, and he graduated from Columbia Law School. So if we could welcome all of our panelists. Thank you all for being here today. We're going to jump right into our program because we have a lot of questions for you. So first, we're going to start with an explanation of what bail is. This is the National Black Prosecutors Association, so most of us have heard of bail. Bail is basically the conditions set forth for a defendant at pretrial in order to ensure their presence at court. Most of the time when we think of bail, we think of bond, which is the monetary value usually associated with bail. Recently, a number of jurisdictions have moved away from cash bail. So this panel today is to discuss the various types of bail reform that are going on and how we can do it better or not. So with that, I'm going to turn it over to the panelists to explain the bail systems in each of your various jurisdictions. We're going to start with Elise, if you want to tell us what Washington, D.C.'s bail system looks like.
Sure. Hi again. My name is Elise Constantinidi. I'm an assistant United States attorney at the United States Attorney's Office in the District of Columbia. And I say that because DC is interesting. As Ms. Thomas just said, I'm a federal prosecutor, but indeed we prosecute almost all of the local offenses in the District of Columbia, with the exception of a few DUIs and disorderly conduct. So we're going to be talking about local DC law when I talk about our Bail Reform Act, but we are federal prosecutors who are administering local law. So with that, DC, I'm happy to say one of the reasons I chose to practice in this jurisdiction, I'm not originally from the District of Columbia, but DC has had a no money bond been a no money bond jurisdiction for many years. It started with the Bail Reform Act in 1966, when we moved away from using the cash bond system, where at arraignment or presentment, a judge would put in a dollar amount on a defendant to, if they wanted to get out of jail pre-trial, to ensure that they would come back to court during the pendency of their case. That was the incentive, was let's set it at a level where folks would be penalized enough, or they lose enough money that it's going to ensure their appearance in court. So in the 60s, DC did away with that. And instead of the presumption of a bond being issued in every case, so there's kind of like a presumption of detention, because if you can't pay for the bond, you're not going to get out. So most defendants were held pre-trial. We moved to a presumption of release. So that's actually a fundamental shift in the thinking of what we think of pre-trial, of the pre-trial posture, because now most of our defendants are actually out on release. And in order to accomplish this objective, what DC did was they started setting conditions of release. So everyone is kind of at a presumption of release, and then the judge would be issuing certain conditions that are individualized to the defendant. So it serves two purposes. One, conditions such that they would help the defendant appear in court again, right? Because that's the important thing, that the defendant is going to come back and through the pendency of the case, but then also conditions that will kind of help the defendant along in the process. Because for a lot of our misdemeanor offenses in the District of Columbia, they're addiction-based, they're mental health-based. And I mean, that has been more of a recent change. We have community courts in DC, but they'll have to do things like go check in with a case manager, be compliant with their drug testing and mental health treatment. Those are all examples of conditions of release that they have to adhere to remain out in the community. So not only are they free, but we're also connecting them to services to try to treat the root problems that have led them into the system in the first place. Now, additionally, we have something within the Bail Reform Act. We have statutes that act as deterrents for defendants not to show up during their court hearings, right? So instead of the bail jumping for losing the bond amount, now they're facing potential additional criminal penalties if they fail to appear for subsequent proceedings. And those are called Bail Reform Act violations. So if a defendant willfully fails to appear, and we use the word willfully because there's lots of reasons why a defendant may not be able to make it in court when they have signed notice to appear. If they willfully choose not to appear, then they can be charged with an additional offense. In most situations, it's going to be a misdemeanor. If it's a felony case, or if they're pending sentencing, it's going to be a felony. And then that becomes, they're eligible to have a bench warrant issued, and they'll be subsequently arrested. So the deterrent there is an additional charge if the defendant fails to show up in court. All right. So that is how functionally we ensure that the defendants come back, because that's the argument, right? How do we know they're going to come back? They don't want another conviction on their record. And yes, there is the case where some people rack up Bail Reform Act violations, but for the most part, it has been incredibly effective. People show up, they like their liberty, they want to continue to be free, so they try hard not to violate their conditions of release. Now, that being said, there are some offenses where the presumption is not release. It's going to be detention. And those are the most serious offenses. And again, so when we talk about the other cases where it's more of an appearance of court, that the court is assessing whether or not the defendant is likely to appear in court again, here in these cases, it's a dangerousness determination. Does the defendant pose a danger to the community? And those were added later. Those were not in the original Bail Reform Act of 1966. Those have been added statutorily later. The most common one is 1322 B1A. That applies to all dangerous offenses, which are a category of cases, and all violent cases. And those cases that involve firearms, there's a rebuttable presumption for detention. So now it is a burden on the defense to explain to a judge using various social factors such as ties to the community, education, gainful employment, why the presumption should be rebutted that that individual is not a danger to the community. So the defense has an opportunity to tell the judge, yeah, my client is charged with a really dangerous crime, or my client is charged with a gun offense, but here are all the factors, which, by the way, statutorily, the court they must weigh. And this is why the presumption has been rebutted. And if it's adequately been rebutted, weighing those social factors, which again, the court must apply, then the court puts them on individualized conditions, like I just discussed. And that could be house arrest. The standard for that is the least restrictive conditions necessary to ensure the safety of the community. So a lot of times that's house arrest, a lot of times that's a curfew. But again, that keeps most of our defendants out of pretrial detention posture for their cases, which can churn for many, many years. So I have found it effective. Yes, we do have defendants who fail to appear. We have defendants who abscond before their trial date, but I find that those are the minority. And for the most part, folks are compliant. And when they're not in compliance, they have a pretrial conference, and then the judge gets to reassess whether or not they violated their conditions of release. And if they have, in a way that shows a willful disregard for those conditions, they can be revoked back to incarceration. But it's only after they've been given the opportunity to be out in the community, to abide by those conditions, that they're then incarcerated. And I think that that is why DC has lower incarceration rates than we could, given the amount of crime and our crime rates, which are currently very high. But I also am proud to be a prosecutor here, because I feel confident going into court that when I'm asking for a hold, when I'm asking for someone to be detained, it's because not only do I believe that the defendant poses a danger to the community, but a judicial officer has found by clear and convincing evidence, which is the legal standard, that that individual also poses a danger to the community.
Thank you for that, Elise. Now we'll turn to Mr. Grace. You're still muted.
Good afternoon, everyone. As stated, my name is Bobby Grace. I'm currently a deputy district attorney with Los Angeles County. California has gone through some twists and turns with bail. Many of you probably know that California attempted to change bail first through the legislature, and they actually passed a law that would have done away with money bail. And the previous speaker did a really good job of giving an overview of how bail works. And I would venture to say that her explanation of it cuts across all jurisdictions, both state and federal, and the way that most jurisdictions now are looking at how bail should be applied. So in California, the state legislature attempted to get rid of money bail and actually passed through both the state Senate and the state assembly a law that would have done away with money bail in California and went to a risk assessment system. But because of the outcry from the bail industry and other folks, they put off implementation of the bill until there was a proposition on the ballot in 2020, which would settle the question in a statewide vote among the general voters as to whether or not we were going to do away with money bail. In California, we're known as being very progressive, but we do some quirky things. So almost every progressive proposition in 2020 that was on the ballot did not pass, including restoring affirmative action and including this bail reform law that would have done away with money bail. So we are essentially back to square one. Here in Los Angeles, we did elect a progressive prosecutor, George Gascon, and he is among many changes that immediately took effect upon his election and swearing in. The presumption here in LA County is that we are not going to ask for money bail on the vast majority of offenses here in Los Angeles County. What's still in effect is money bail for violent offenses. And kind of like DC, here in Los Angeles, we've had a big uptick in violent crime. And so the previous amounts of bail for various crimes, including murder, assault, robbery, all of those amounts are still in play for those types of crimes, and prosecutors are asking for bail in those instances. Due to COVID, prior to District Attorney Gascon's election, we had already moved to a zero bail policy for most nonviolent charges here in Los Angeles County. So we were trying to make an effort to try to get out as many people as possible who were being held on nonviolent offenses. So to wrap all this up, most of the counties in the state of California are taking up some question of bail reform. Most of the counties have not implemented a risk assessment system. And curiously, the state legislature did not put money into their bill that would have done away with money bail. So that's going to be an issue going forward. Can the counties come up with a risk assessment system? And I'm sure we're going to get into it as we talk about this. What is risk assessment? What does it measure? How much does it cost? Is it discriminatory toward people of color, in particular, Black people? So I look forward to getting into that discussion, but that's kind of the overview of what's going on in California and in particular, Los Angeles County.
Thank you very much, Mr. Grace. Mr. Guria?
Thank you, Janae. Thank you for having me this afternoon. As was said already, I've been in the Brooklyn District Attorney's Office in New York for over 30 years, and I've seen an evolution with bail. My office has tended to be a more progressive office, so we often were not asking for bail in some cases. But in 2020, the entire landscape shifted. And there was a legislative move to have a new statewide change in the bail laws that went much more progressive than had ever been done before. The interesting thing, it was referred to before it passed as the bail elimination law of 2019. While it didn't completely eliminate cash bail, it really, really reduced it. And as similarly has been said by other people, in New York now, for the majority of misdemeanors and nonviolent felonies, there is no cash bail. That has been eliminated. There are some exceptions, but for the most part, nonviolent felonies and misdemeanors, there is no monetary bail. Now, for prosecutors to ask for a monetary bail, the law now specifies that there has to be a qualifying offense, and those qualifying offenses, for the most part, are violent felonies. So at this point, that kicked in January of 2020. And ironically, as Bobby Grace mentioned, COVID kicked in New York several months later. So I think we would have had a bigger issue involving jail population in COVID, but around December of 2020, most of the judges in New York, knowing that there were individuals who were currently in jail or unable to make bail, most of them were released in anticipation of the change in the law coming in. Now, there were some problems with the law, and prosecutors and judges both complained when it kicked in, because in some instances, there were certain categories of crimes which were not considered, certain hate crimes, some sexual offenses, some vehicular crimes that were nonviolent crimes of a certain nature, but they were very serious. And in July of 2020, the statute was amended and those were added. Plus, there were some aspects given so that this way there'd be some more discretion with respect to what could be considered. But even in the case where judges can consider bail, it has been specified in the law that a judge has to consider the least restrictive means of securing the defendant's appearance, and they have to provide at least 3 forms of bail. So aside from just cash bail, the judge also has to provide either an unsecured bond or a partially secured bond, or some other type of basically pre-trial supervision that might ensure that the defendant would come. Now, in the past in New York, a person could languish in jail just based on the fact that they failed to appear in the past. Now, that is not a basis just to have somebody sit in jail pending trial.
Thank you so much, Mr. Greer. Mr. Warren?
Hi, can you hear me?
Yes.
All right, well, first of all, good afternoon, everyone. I want to thank the NBPA and our own Janae Thomas for hosting and inviting me to participate in this event. So the question is, what's the bail system like in Florida? And imagine performing a Beethoven symphony with a kid's piano and a pair of kazoos. That is the bail system in a nutshell. We have on paper this elaborate, nuanced process. There's an entire chapter of Florida code that deals with it. In fact, there's a second chapter that deals with pretrial detention. But just that first chapter, chapter 903, it's about 20 pages. It's probably 10,000 words. And the specific subsection dealing with conditions of release identifies 13 separate factors, 13, for a court to consider. Now, if you ask someone with no experience in the criminal justice system to read the relevant bail statutes and to estimate how long a hearing should be to arrive at bail, what do you think you'd get? People would estimate 30 minutes, an hour, a few hours. Well, in Florida, at least in Hillsborough County, judges make bail determinations in about 1 to 2 minutes. 1 to 2 minutes. Now, that's not a knock on judges. This is a numbers game. We have about 150 to 175 cases a day. We have one courtroom that's dedicated half of its time to doing initial appearances where bonds are set, and that's all the time they have. If you spent 5 minutes for each of those 150 to 175 cases, you'd spend 12 hours each day. We have about 4 hours of time to do it. We simply don't have the resources. So what is it that we're supposed to be determining? Well, similar to what my colleagues have said in their jurisdictions, the goal in Florida and the law in Florida is to assure the defendant's appearance and to protect the community from further harm. Now we have a specific statute in Florida that says there is a presumption in favor of non-monetary conditions for as long as it's not a dangerous crime. And it says that when monetary conditions are implemented, it has to be determined by a judge that they are, quote, necessary. So money has to be, quote, necessary to assure the person's appearance, to protect the community from harm, and to assure the integrity of the judicial process, whatever that means. Never seen a connection between somebody paying a bond, a cash bond, and assuring the integrity of the judicial process. But that's what the law is on paper. What do we actually do? How do we actually make determinations? We have a uniform bond schedule. We have a standard amount per offense. It's higher for more serious offenses, of course. $15,000 for a first-degree felony goes all the way down to $250 for a second-degree misdemeanor. And that's how bonds are determined, with a calculator. The music as composed on paper is not the music that you're hearing in the courtroom. The bottom line is that every single day, every single case, we violate Florida law. And the people whose rights are being violated are the poorest members of the community. When we hear people talk about different systems of justice for rich and poor, you don't need to look at the quality of the attorney or what happens at trial. You don't need to look any further than the very first court appearance when bond is set to see how differently we treat people based on how much money they have.
Thank you for that. So at this point, I would like all of the attendees to enter the word labradoodle into the chat. If you cannot spell that, don't be embarrassed. I'm going to spell it for you. Labradoodle. A labradoodle is a breed that was originally bred a Labrador retriever with the standard poodle. That is for CLE purposes. As Bianca stated, you have 20 seconds to do it, and then we will continue on our program. And no, she did not make the words easy for me, labradoodle. Fix that. Thank you all for that. So now we want to get Mr. Berry involved. Mr. Berry, if you could explain to us in your experience, what are the benefits and drawbacks of a cash bail system?
Great. Happy to be here. Thank you so much for inviting me to participate. I've followed the National Black Prosecutors Association from a distance for a long time, so really honored by the invitation. I think all the presenters have done a really good job of pointing out some of the problems with cash bail, and I think it's obvious to all of us as attorneys that using a wealth-based system has inherent challenges. In our society, unfortunately, many communities that are left out of economic opportunities are also disproportionately impacted by the criminal justice system, and we compound those injustices through a cash bail system. One of the things that I have been most troubled by is the involvement of the private bail industry in the money bail system. I find that to be particularly problematic in that families that can't afford the entire bail amount in California, which is about 97% of not able to post the entire bail amount for their loved one, go to a bonds agent to cover that cost, and they lose, of course, that 10%, no matter whether their loved one makes all of their appearances and complies with all their terms, that money is forfeited. But in a state like California, we do about 205,000 bonds every year, and that ends up transferring about $440 million of money from predominantly poor families to the private bail industry. And I find that transfer of wealth particularly troubling. We've all heard stories, and I've done both defense and prosecution work. And so I've had clients who have had family members put up homes, who have foregone educational opportunities, made very significant life alterations to be able to secure the freedom of their loved one. And so the concern for me really is that there really is not an appropriate place for wealth in this system. I think we all know how much money is in someone's pocket has no indication of whether they're dangerous to us, and that we'd be much better off making those assessments using either risk assessment tools or other indicators to help us understand what the actual present danger is to the community. As Bobby mentioned, in California, several DAs now are moving away from money bail. It is still the default system in our state, but both San Francisco and Los Angeles have moved to systems very similar to DC, where the presumption, at least from the prosecutor's point of view, is release. And that we start from that place, I think we get much better results. And the challenge I think we're going to have as jurisdictions around the country continue to question whether a money-based system is actually equitable and fair, is what will replace that. There are a lot of questions about risk assessment tools, and it's an important conversation for us all to be involved in, particularly prosecutors and people of color to be actively involved in that dialogue about what systems we will replace the wealth system with. And we also are going to need to think about how do we fund the types of supports and services that people will need to be successful while in community. Some jurisdictions in California have done a very good job of that. In San Francisco, we have a nonprofit provider that offers case management support, classes, and many of the things people need to be successful. But many jurisdictions don't have those supports. And so we will also need to be engaged in that dialogue. But from my point of view to the question, Janae, the money is the wrong metric. And we need to move away from that. And I hope that we can encourage more jurisdictions to move towards a presumption of release, and that we can provide the kinds of supports people need in that release state so that they can be successful and hopefully not need any amount of detention to have a successful intervention in their lives.
Thank you so much for that. So now we're going to move into an open discussion. We've heard some of the benefits of removing cash bail, and obviously the goal is to ensure that the community is safe. That's what it was put into place for. So anybody can chime in. What does an ideal bail system look like that is able to keep our community safe, address the concerns of getting through a docket, while also ensuring that we are not incarcerating people because they don't have enough money?
Janae, let me jump in to start. Some of the other panelists have talked about a risk-based assessment. You can have individualized inquiries, which is really what the law requires. So a pretrial services system that takes some of that legwork out up front. But I want to throw out a different type of idea. When you think about one of the primary goals for bond and conditions of release, it's to ensure the appearance of the defendant. Things as simple as regular notifications to defendants, sending them an email, sending them a text, calling them and reminding a defendant that he or she has a court appearance has shown to increase the likelihood that defendants show up to court. Those are really simple things that can be done that have nothing to do with imposing conditions of release that actually save money and achieve the goal of having people show up when they're supposed to.
I think that Mr. Warren makes a really good point, and we've seen a lot of systems like that. There are now some private vendors doing that, but also governments have figured out how to do text notifications to people, how to offer rides. Oftentimes it'll just be an issue of transportation, something really simple to solve for. And I think one of the valuable things for us all to think about as system actors, as prosecutors, is it's a much more cost-effective solution, right? If we can pay an Uber or a Lyft ride for somebody and avoid them being in custody for upward months at a time, likely, that's a huge savings to all of our local jurisdictions, not to mention the benefits to the individual. So I think that's a great suggestion.
Yeah. And I'd like to jump in. It was mentioned before that, some people on this panel have been both defense attorneys and prosecutors, as have I been. And one of the things that I have seen from both of my experiences is sometimes in prosecution, we confuse public safety with public order. And there's a difference, because when I was a defense attorney, the people who used to fail to show up to court often were the least violent individuals in society. They had all sorts of things wrong with their lives. If I can recall, generally, as a whole, shoplifters that had substance abuse issues showed up the least. But they posed the least harm or danger to society. But often the courts would look at their failure to appear and decide, I want this person to show up in court. And so the mechanism was they're going to be in fighting their case because at least we will know how to get there. And that has been a predominant thought of the criminal justice system, to use the court system and incarceration to control court calendars to make sure people don't bench warrant, which is something that we have, that I think all jurisdictions have to move away from. And some of the suggestions other people have as far as pretrial services or other things are going to be important. But then the big question is going to be, if you get away from those type of cases and you start talking about the more serious cases where there is violence and the potential for threatening witnesses or other things, the chief job of most prosecutors is to do public safety. So what mechanism can you do there where if you move away from bail, that you can still be able to maintain both public safety and make sure you move away from bail? If somebody has an idea towards that one, I'm all ears on that one.
So just to piggyback off those points and to address Mr. Warren's point, I completely agree with Mr. Warren's point. I think that if DC had a way to send texts or emails to remind folks, we would have even less bench warrants. Now, that is not going to help our folks who are homeless. We have a lot of folks who have no fixed address here in the district, so that wouldn't really resolve that issue. But I have noticed differences in success levels in folks who have case managers. We have a very robust pretrial service agency here in the District of Columbia. We also have a lot of connective and wraparound services. So the people who are connected and have case managers both in pretrial service agency and in their other connective service, they do better. They get rides to court. They're reminded, they have people calling them, but they have to be assessed and put into those specialty units because, again, it's a funding issue. We don't have the funds to do that for every defendant. We do that for the most vulnerable defendants. And actually, I agree with Mr. Garia's point that it is the lower level drug addicted or mental health consumers that tend to fail to appear. And while they do rack up a lot of what we call Bail Reform Act violations, because under the letter of the law, they have jumped bail. But that being said, we don't have them revoked, or the judges are hesitant to revoke their conditions of release because they recognize there's an underlying problem, and they are usually removed into these community courts to try to treat the underlying problem that's preventing them to getting to court. And some of that is homelessness and addiction. So I think that's a long-winded way of saying it can be done. I think we do it well. I think we can do it better, but I do think that the solution is getting more folks to just help these people along the way, because a lot of them don't want to miss court. They don't do it because they're truly skipping bail. They're doing it because they don't remember, or they're a slave to their addiction, or they don't have childcare. So I think more funding to these service providers would be a possible solution to those issues.
I wanted to jump on another thing that Mr. Guria raised, which is at the high end of the spectrum, folks that were concerned may actually harm another person while they're released. And that really is the question that we're grappling with in California. We have a case in front of the California Supreme Court, People versus Humphrey, that is, the court is trying to resolve exactly that question. Should we have preventative detention in cases where we're so concerned about the public safety that we don't think any amount of money is an appropriate deterrent to their potential violence. And how broadly should we draw the circle of what those categories of crimes and offenders should look like? And in our Constitution right now, it's a very narrow circle, as we would all expect and hope, since it is a detention you cannot escape without the court deciding that you are no longer a danger. And it really is capital cases, cases of violence or of a sexual nature, or cases involving a threat. However, there's another part of the California Constitution that broadens that circle, or is argued to broaden that circle. And the question that the court is grappling with are there other crimes that don't fit in those three top categories that should be considered for preventative detention, such that we couldn't completely eliminate monetary bail, but we would still be detaining some people pre-trial? And how do we manage that? And I think that is a hard question and an important one for us all to be grappling with, because obviously the denial of liberty, the ultimate denial of liberty in a pretrial status, is a serious consideration.
Well, Ms. Berry, I can tell you in DC what we do to address that issue. We do, as I mentioned before, we have preventative detention in dangerous crimes, gun offenses. That's a statute called 1322B1A. And the way that we've handled that, the intrusion on someone's liberty in a pretrial posture when they're presumed innocent, is that there's a statutory amount of time that we must get the case to trial. And that's 100 days. We have 90 days, that's 3 months to indict the case. On the 100th day, it must go to trial. Now, of course, on defense's motion, that time can be told if they are considering a plea offer or if the defense is not ready, but we call those 100-day cases. And that kind of offsets the concern to the liberty interest of the defendant, because he knows at max, he or she knows she's only going to be held 100 days without having a trial. And that strikes a nice balance with the ensuring the safety of the community, because if this person really has done what they're alleged to have done, they are probably going to be convicted at trial, and then they're going to be detained in any event. And sometimes they can get credit for the time they've served in their pretrial detention posture. And we found that very effective. Now, for homicide cases and attempted murder, it's those two crimes in particular have another statute governing them, which is an indefinite detention. But we have a very, very high legal standard we must meet to have them held indefinitely. And that's substantial probability of a likelihood of success at trial, which is essentially beyond a reasonable doubt at a very, very early stage of the prosecution. So again, it's not perfect, but because DC's been at this for 50 years, I think we have a pretty good model.
So to follow up on that point, if you all could explain how diversion in your area fits into all of this. Have you found that more diversion offers helps to decrease the people incarcerated due to non-monetary funds, or decrease? How does the diversion aspect of that fit into all of this?
Let me jump in. So diversion has been a very good tool, I think, across all jurisdictions. And if you're not using diversion as a tool to not only to address issues with respect to detainees, because the reason why diversion was implemented is to address many of the underlying issues of why people are in custody. So if you don't have a diversion program for mental health, if you don't have a diversion program for veterans, homeless, many other different factors, you're going to have a large population in your jails who don't need to be there. The question is going to come back to what do you do about people who are alleged to have committed violent crimes that go beyond the circle that Christine talked about, and you're in a jurisdiction where it's impossible to go to trial within 100 days. Like in California, in Los Angeles County, most cases, especially murder cases, they're not going to go to trial within 2 years, let alone 100 days. So jurisdictions that are dealing with a large amount of violent crime, jurisdictions that are dealing with socioeconomic issues that entail a lot of people that are homeless, mental health issues, those kind of things. That's what these large local prosecutor offices are dealing with on a day-to-day basis, and trying to grapple with, what kind of money can the local jurisdictions come up with to do diversion programs, and how are you going to set it up so that it can release as many people who should properly be released, but do you have the support staff and structural support in the community to make diversion work? Here in Los Angeles County, we do have a very robust diversion program in a lot of different areas, and the county has put money behind it. But if you don't have the money to support the diversion programs, they won't work.
I have to agree with Bobby on that. The last 3 DAs I've worked for have all been pioneers in one way or the other in diversion programs. And you have to have partnerships in the community, because those are the people who often are able to help with the supervision or give second chances to the people that are involved in the diversion programs, or they're the non-government organizations that have the expertise to deal with whatever problem the offender has. And so we've done a lot. Not only does it have an effect on reducing the number of people that are incarcerated, the studies have shown it's done a tremendous job at reducing the recidivism, which is important, because then you're not seeing repeat customers. As one of the DAs I worked for said, his goal was to try and stop all of those types of defendants that were basically getting arrested over and over again for minor crimes and doing life on the installment plan. And I'm sure everybody in different offices have seen that category. If you can reduce that category, you'll do a lot. You won't have to ask for bail for as many people, because those people will be removed from the equation.
And one thing just to add to what Bobby and Charles had said about diversion is keeping in mind that civil citation programs are another way to reduce the strain on pretrial incarceration. We have a lot of people here who would otherwise have been arrested, but for the fact that we've created civil citation programs. So now they're getting essentially the equivalent of a traffic ticket, and as long as they comply with it, then they never end up getting charged. But so many of those offenses, even though they're low-level offenses, and our civil citation programs are limited to misdemeanors, you would still see, on average, 30% of those people end up not being able to afford the bond that was imposed on them if they were arrested, and then they end up sitting in jail until their case resolves. So it's not truly diversion, because they're never coming into the system in the first place, but it's another wrinkle on the broad idea of diversion that reduces pretrial incarceration and helps to even out this uneven playing field of the criminalization of poverty that we have with a cash bond system.
So we have a question in the chat that kind of ties into the area of diversion. Do any of your offices extend diversion to alleged offenders?
I think,
Yes.
was it about felony offenses?
Oh, sorry, I forgot the word. Sorry, I can't read today. It is felony offenders.
Go ahead, Charles.
No, they're depending on the circumstances, there can be diversion in some circumstances for nonviolent felonies.
And some jurisdictions have what is known as a office hearing program, where even cases of low-level violence that occur in the community, they can be brought in, and people can, a prosecutor can bring the parties in and come to an agreement, a non-binding legal agreement, but an agreement that prosecution will be foregone if they meet certain conditions with respect to that. And LA County used to put a lot of money into the office hearing program. It's not used that much anymore, but it's another way to achieve diversion for more serious cases or alleged cases within the different jurisdictions. But for the most part, I would say that most local state jurisdictions are not going to use diversion for most felony offenses.
Yeah, we use diversion for low-level drug offenses that are felonies, our distribution, our PWIDs, because again, a lot of those folks are very low-level dealers that are usually addicts. So we have community courts, we have a mental health court, and we have a drug court. And so my office will extend a plea offer that says, if you plead, we will transfer this case to drug court, we'll transfer this case to mental health court. And at the conclusion of your diversion period, if you have completed the program successfully, you will then either have the case dismissed or it will be, you will be pleading to a misdemeanor case. And I'm sorry, I'm being told, yes, possession with intent to distribute is PWID. I'm sorry, I'm so used to talking to prosecutors that we know the acronyms. And so then instead of having a felony offense, we'll have a misdemeanor possession offense. But again, that is limited to drug cases. Every now and then a gun case, because DC's laws are so strict with guns that even if you're licensed in another state and you're driving through the district, you'll still get a felony offense. So in those rare circumstances, we'll also extend a diversionary agreement.
And I forgot, there also are some circumstances with domestic violence case, we have domestic violence courts. So while those can involve violence, it can also be diversion aside from drug instances in those cases as well.
I would just mention in San Francisco, under both former DA Gascon and current DA Boudin, there are some interesting diversionary opportunities. One is called neighborhood courts. If people are interested in looking into that, where we train community members to handle disputes. Those are misdemeanor charges and some low-level felonies. It's a completely restorative process. It's pre-charging. It's a quite interesting approach. And we also have had, over my time in the office there, a young adult court, which is post-charging, but it's all felony cases. It's almost all young men of color on relatively serious assault or robbery charges, but where we keep them in community and provide wraparound supports to them, case managers, and we have some great success stories out of that.
Okay, so now for our panelists, it's time for another word. This one's a lot easier. It's Amazon. Jeff Bezos stepped down as the CEO of Amazon. I would spell it for you, but if you're like me, you use Amazon enough that you know how it's spelled. So as they're typing, another question for our panelists. You guys have been mentioning a lot of barriers, but the question is, what are the barriers in your specific jurisdiction that prevent bail reform from looking the way you want to? I guess another way to ask the question is, who are the actors involved in the process that are making your life a little difficult as you're trying to implement these procedures?
I mean, I think in most jurisdictions, it's judges that ultimately are deciding the bail amount, right? So in California, even in offices like San Francisco and LA, where the DAs have said the presumption shall be released and we're not requesting bail be set, we're requesting some conditions to their release. It's ultimately up to the judge, and in both jurisdictions, less so in San Francisco, but it's newer to LA, a lot of judges still setting bail. And, you know, for the people that can meet that but have real needs, I think it's unfortunate because they're not getting the supports and services they need in that valuable pretrial moment, and they're paying the money. But that's the ultimate decider of bail in California.
And to piggyback on what Christina's saying, I think in every jurisdiction, there needs to be real agreement between all the justice partners as to how to go forward with bail reform. Because if the judges aren't on board, if you have some sort of release officers, like let's say probation, in California we have probation, maybe they're going to be involved, maybe they're not. You know, what is it going to look like in terms of the structural support for people who are going to be released? If those people aren't on board, if defense attorneys aren't on board, then you're not going to have a coherent bail system that everybody's going to be invested in. And I think Los Angeles County is trying to do that, and they've been engaged in it for a while. And I think the new district attorney's approach is going to really push the entire system, justice system, to come up with something that's workable. And I think if that happens across the nation, where all of the justice partners get together and just embrace first the concept of bail reform, it's here, it's happening. And then how can you make it work in your jurisdiction? Where can you find the money to make it work? Because it's going to be a monetary thing. But in the long run, as all the panelists have said, it costs way less money to have pretrial release than it is to keep people in custody.
And I think whatever bail situation or whatever pretrial release situation you have, it has to make sense to the partners involved. Otherwise, you're going to get pushback. I think initially when the bail reform law went into effect in New York, we saw many judges who felt that it had gone too far, removed all their discretion, pushing back. Some tried to say it was unconstitutional and because it removed all their discretion. It ultimately did get amended, and they added some categories of things that gave judges more control. But, you know, especially older judges were inclined to feel like all their authority was taken away. But then you also have the reverse, because there are younger judges out there now, this is their reality, that when a prosecutor has a qualifying offense and they do believe that this is a person they want to ask for bail, sometimes the judges can't handle the altitude because they're so used to releasing everyone. And now you have a situation where they hear a bail recommendation and they're not sure how to handle that. So I think it's going to take education on all sides, and everybody, as Bobby says, everybody has to be invested. Otherwise, you're going to still get the old biases kick in, and then it's not going to work out, you know, in a way where they're not taking categories and factors into effect that they're not supposed to be considering anymore.
Just to add to that, I mean, we've talked about the drawbacks of cash bail, how it's costly. We've talked about the fact that it's counterproductive, and research shows that people who end up in jail pre-trial usually end up with worse outcomes in terms of longer sentences and job loss and breaks in their family. And we've been talking about how it's discriminatory too. I mean, look, this is the National Black Prosecutors Association. This is a discriminatory practice that disproportionately affects people, the 3 Bs, black, brown, and broke. But you want to talk about how to actually convince people to change the system, you need to make them understand that it is illegal. What we're doing every day, to go back to what I said earlier on the panel, is violating the law, at least in Florida, for what we're supposed to do in terms of when we are allowed to impose monetary conditions, in terms of what the presumptions are for pretrial release. We violate that routinely. Prosecutors, judges, defense attorneys, and no one seems to mind. And it's this entire system that needs overhaul. And we can make little tweaks in it, such as we've done locally, allowing for more RORs on certain types of offenses and working with the judges to try to have financial-based inquiries to see if whether somebody can afford the amount of bond that's being imposed. But at the end of the day, we've created this structure that routinely is violating what it's supposed to be doing in practice.
So can I ask you a question, Mr. Warren? I'm just curious about this. You mentioned in an earlier response, you only have 4 hours to get everything done. Why do you only have 4 hours for arraignment court? Ours goes on as long as necessary for the day. So is that something the court has mandated? Is that kind of a informal rule? I'm just curious.
it's not a formal rule. We have one court that handles initial appearances here, and that court's responsible for doing detention hearings as well as initial appearances. And so on any given day, half the day is spent doing detention hearings, which can take several hours, and the rest of the day is spent doing the 150 to 175 initial appearances that we have. Now, the numbers are down a little bit during COVID, but in a non-COVID year, you have several, again, 150 cases that have to be handled in the span of about 3 or 4 hours. And so the judges just get in the habit of, they hear the case, they look at the offenses, they say, okay, you got 2 third-degree felonies and a misdemeanor, carry the 4, and here's what your release conditions are.
Yeah, I'm asking because the section I'm in charge of, we oversee our arraignment court operations, which I think is very similar to what you're describing. And unfortunately for the judges and court staff, it just kind of goes as long as it's going to take. And again, we do have the help of pretrial service, who does a lot of the inquiry that the judges are doing in your jurisdiction. But then they have a very fulsome pretrial service report that they're reading from, and they get representations from both counsels, and they can make an informed decision. And yes, some of the hearings are more than 2 minutes, some of them are 5. And sometimes you're going to be in that courtroom for 6 hours. But at the same time, everybody who's eligible to be detained has been properly inquired of, and they've had their hearing. And we do have detention hearings there. If they take testimony, we do have a second courtroom for that, which is usually 3 days after they're initially held. So perhaps that is alleviating some of the congestion that you're describing. But for the most part, it's just the contingent of people we have working in the courtroom, and prosecutors and defense attorneys who are just kind of prepared to stick it out. And the court does get cranky. You know, I get callbacks every single day from judges. I get emails from them on the bench begging for us to get those cases filed. But our response is, we just have to make sure that they get that, you know, they're properly vetted and they're properly charged and they make proper arguments. So I hear what you're saying. I'm just wondering if perhaps you guys can push back a little bit and say, we can't put a time limit on justice. I'm sorry, guys, and do a rotating calendar in the courtroom so they're not stuck there.
I mean, you're absolutely right. And in full disclosure, I was an AUSA in DC, and so that's how it works there. And this was a couple careers ago, but and DC follows, as you described, they have a really good system on paper, and it's followed in practice for the most part. And it mirrors the federal system, which is, in the federal system, the first order that the court has to decide, the first determination is this person being detained? And if the person's being detained, then they're being detained. And if they're not being detained, then they're not being detained, but they're going to fashion circumstances that allow for the person to get out on pretrial release. In Florida, the state system is supposed to work that way. However, judges are not saying you should be detained, you shouldn't. They're just saying this is how much money you have and this is how much money you're going to pay. Whether you're detained or not, the judges really don't even have clarity into, because they have no idea who's posting bond and who's not. So from the very beginning, the system is messed up here because we're not doing what any good pretrial release system should do, which is determining right up front whether someone is a threat to the community and a risk of flight, or they're unlikely to show, in which case they need to be detained, or they're not, in which case they don't need to be detained.
So we have time for the one question we have in the chat. So I'm gonna ask it and open it up to anybody to answer. How will computer-based bail reform or other kinds of bail reform improve the current disparities when risk factors include race, class, income as some of the main factors for determining a person's likelihood of returning to court when released? That's a loaded question, but anybody feel free to jump in.
Well, I think somebody who's working in a risk, who uses a risk-based assessment system should jump in here.
So I've been part of both not having a risk assessment, having a risk assessment, and then moving away from a risk assessment. So maybe I could offer some thoughts on that. in San Francisco, when we wanted to start moving away from money bail, was early in the conversation that we're having as a country around this. And so we looked to a publicly available algorithm that was created by the Arnold Foundation. And we used that on the belief that it was the most restrictive in the number of factors it was considering. We were concerned with some other tools out there that ask, as the questioner presented, questions about employment, residence, education, things that would certainly indicate some biases in how they determine risk. The Arnold tool really looks at prior criminal contact, and though better, obviously, patrolling, arrests, and prosecutions are executed in racially disparate ways. And so there is still a bias baked into even that tool. And so I think the learning that we had through using the tool was that, one, it was helpful for the prosecutors in our office to see an unbiased evaluation of person after person if you assumed that those criteria were valid considerations. It did recommend release in many more cases than what we were currently suggesting release for people. And it did increase the release rates, both our office's recommendations and the judge's adherence to that. So I think that those were positives. But as I said, because it considers somebody's past criminal history, it obviously disfavors Latino and African-American individuals. And so that was something that was troubling for DA Gascon and for DA Boudin. The office now uses it as one factor to consider. So it has a place, but it is not the office does not rely on it as the basis for making its decisions, and moves towards a presumption of release with supportive services in the least restrictive manner possible. But the tool is still available, and it's available to the judges. I would say one benefit of having a tool like that is it allows for the collection of data, particularly in offices that are moving away from bail, but where the court is still using it, is, I think, a helpful feedback loop for the judges to understand whether the bail decisions they're making are appropriate, right? Or maybe they are indeed racially disparate, and that's something they want to look at. Maybe they're deviating to release or detain some categories of people, contrary to what the tool is recommending. So it can have some value in that regard, but I do think it is difficult to identify a risk assessment tool that doesn't factor in so many of the inequalities that we already have in the rest of our system. And so it is a tricky balance.
One of the things that also the New York statute does is they have a data compilation portion of the statute. So this way, as time goes by, obviously our statute is relatively new, but they built that into the statute. So this way, as time goes on, they can see if any of the assumptions that they made about what was good or bad about the decisions that they made about what they were doing, whether it's borne out by statistics and other things. In this way, it will put them in a position that they can make changes in the law that more reflect whether or not it actually has made it easier for, and less restrictive for people to come to court without any type of penalty.
So one more question. After hearing all of the different types of bail reform efforts across the United States, what is each one of your opinions on whether there's a one-size approach to bail reform? When you all hear each other talking, do you think, man, we could do that here? Or do you feel like there are some barriers in your jurisdiction that prevent Florida from looking like DC or New York or California?
Yeah, let me jump in quickly. Our jurisdiction is different because our laws are different. We don't have a least restrictive conditions piece of the statute like you do in DC and New York and in California. I do think that the law on the books is set up in a way that we could have a successful bail system. We just don't have the resources allocated that are necessary to implement it.
You know what? I think the big piece in all this is the judiciary, and the one universal thing that we could all work on, trying to come up with the resources and educations for jurists, so that they're not out there making the sole call on who gets out and who doesn't. I think most jurisdictions are moving toward no cash bail for nonviolent misdemeanors and felonies. That's just the wave of the future. The question is going to become on low-level violent felonies, some domestic violence cases where there's no injury. Does the judge let that person out? There's a famous case in Los Angeles County where something like that occurred, and a judge let someone out, and that person went out and killed the victim. No judge wants to be on the front page of the newspaper having made that decision. So we've got to work as a society and within the criminal justice system to make those types of assessments easier within the system, and to make those decisions less on any one particular judge. And as the State Attorney Warren says, we've got to come up with the money that makes it easier to have pretrial release, because there's structure there and support there for everybody that we're letting out. And as everyone has said, it's more cost effective, but does each local jurisdiction want to put up the money to do it?
It definitely has to be a transfer of investment to those types of services, because if you just remove the cash bail without any type of services, then you're basically not giving any of these individuals support, and they're going to continue to bench warrant. And then, that gives ammunition to the people who are saying that these reforms should have never taken place to begin with. And it also impacts, on the public safety, because the other elephant in the room that nobody has mentioned is, I did violent crime prosecutions for many years. Other people here have done it. The victims in those cases also are predominantly Black and brown, so they also have a right to being safe. So we have to figure out that balance. And if we don't have a system that is going to try and do some type of supervision and make sure that the individuals in these cases are not just thrown to the wind, it's not going to serve anybody.
I guess I would say, I think that the large scale tenets of what we've all been talking about are applicable across the country. A system that has a presumption of release and the least restrictive conditions are things that, even if they aren't in statute or in the current system, are things that prosecutors have a fair amount of authority to start nudging the rest of the system to move towards, and are important reforms. Obviously, as everyone has mentioned, there are state law differences between the way we all practice that will factor into that, but moving away from cash bail for the vast majority of offenses and towards a presumption of release is something I think that many jurisdictions are flirting with, and some are actually implementing, and I think has broad application.
So we have a last question in the chat, and then we'll do final remarks after this. Suzanne Sweeney would like to know, significant organized identity thieves pose a different threat to the community that is not violent, but still affects security of the community. How do you weigh in those types of offenders on bail reform efforts? It's open to anyone.
Yeah, I think when we talk about danger to the community, we don't necessarily just mean violence, right? So I think that it's just how you write the statute. If you make a dangerous offense something that where you are victimizing folks, and you statutorily put in something like identity theft or fraud, which unfortunately are becoming all more common these days, then you can work that in. So now there's a presumption of detention, or it's falling under a detention eligible statute. So then you can go and make that argument in court and say this person's out of control. And if we let them out, they're still going to have access to a telephone, and they're going to continue to defraud the community. So I would say, I think you can. I think that can definitely work in a no bond jurisdiction if we just sit and really think about all of the felony offenses and whether or not they would be detention eligible. And by doing that, by assessing their potential impact on the community and what it would look like if somebody who could not comply with conditions would continue to reoffend. So I think it's possible.
I definitely agree, because there are circumstances where now I am doing financial crimes, and one of the crimes they amended the statute to include was enterprise corruption in the first degree, because there's a recognition if somebody is engaged in doing a financial crime of a major magnitude, that can have as much of an impact as a violent offense. Now, it would be a situation where prosecutors would have to be very careful not to expand things too far. If you have, say, an insurance company as the victim, that would probably not be the right case to go. But if you have somebody who's basically trying to victimize a series of elderly people and just running through the community and fleecing them of their every last cent, well, that would be, could be a major, major attack of a financial nature on that community, and that should at least be something that should be considered and not just immediately excluded.
I agree with what Elise and Charles said, but it's worth noting that in Florida, the statute talks about monetary conditions are appropriate if they are necessary, as I said before, and the necessary describes physical harm. So actually under Florida statute, that an identity theft or a white collar fraud situation would not justify monetary conditions of release.
No, I understand that. And in fact, originally when the law was changed, I am handling a case involving defendants that defrauded the government of millions and millions of dollars. And one defendant was in on $1 million bail, and he went from being in on $1 million bail to going out ROR, just based on the calendar. So at some point, there needs to be, in a situation like that, a hope for at least a happy medium.
I think Charles raises a really good point that the current bail system doesn't do any better by those kinds of offenses now, right? So maybe in these reforms, there's an opportunity to think more in depth about the different kinds of harm to a community and how we prevent it, not even just in the pretrial moment, but in the post-conviction situation, right? That person won't be jailed for life in almost any of our jurisdictions. So what does it look like to intervene in that criminal behavior over the long term? And how do we keep the community safe from that kind of behavior? I think they're hard questions, but important ones as we're reforming the system to be thinking about how do we improve our interventions across the board.
So now it's time for all the panelists to give their final remarks. And I would like to add that we've had a lot of positive feedback during this presentation, and there are a lot of NBPA members interested in getting involved in the various jurisdictions. So if you all are comfortable, if you could put your contact information in the chat, and during your closing remarks, if you all could just explain how we could get involved, if there's something that NBPA could do to help in any of these jurisdictions and pushing reform or not, however it works. We'll start with you, Mr. Warren. We'll go in reverse order.
All right, well, thank you again for allowing me to join today. I guess my closing thoughts, I'll repeat things that I'd said before. One of the biggest problems we have with the cash bail system is that it's discriminatory. I think we can leave aside for a moment the fact that it is extremely expensive, that it's counterproductive. One of the hallmarks of our judicial system is supposed to be that everyone is treated equally. And here we have blatant examples of where people are not treated equally and where people are treated differently solely based on how much money they have. You have disparate outcomes based on the ability to pay, which is just not what our system is supposed to be about. So I think as we keep in mind the problems with cash bail and solutions for the future, that's what we need to focus on. We need solutions that don't punish poor people simply because they're poor, while they're exercising their constitutional right not to plead guilty, to have an attorney, to go to trial, to contest the charges, to make the state prove the case beyond and to the exclusion of a reasonable doubt. We shouldn't be punishing people just because they're poor.
Mr. Gurria?
Thank you. I appreciate being on the panel today, and I just want to say, we have to keep in mind the purpose of bail was to ensure defendants return to court and be held accountable on the charges that have been leveled against them. They haven't been found guilty of anything yet. Often in the past, the bail system was a mechanism used just to make sure that defendants were warehoused somewhere in between court dates. And that was essentially what many people involved in the criminal justice system assumed was the right thing to do. And we see now that has serious flaws, and it's expensive, and it's just not needed in most cases. The New York bail statute is a good move in the direction to try and resolve some of these issues that have existed with monetary bail without ignoring the public safety concerns. For most nonviolent felonies and misdemeanors, it's no longer an option. However, prosecutors still have to be able to seek bail or some other alternative for individuals who pose a serious risk to our citizens, because that's always going to be a component that's important for prosecutors to be able to do as part of their duty.
Thank you. Mr. Grace?
Thank you. I also want to thank the NBPA for allowing me to be part of the panel and really hosting such an important discussion. I think that there's a tremendous opportunity for this particular organization to weigh in on a national level and talk to the current administration and talk to the Congressional Black Caucus and other people that have the ear of the Justice Department and the new president about the issue of bail, connecting it to the George Floyd criminal justice bill that they're trying to pass, and probably try to amend it to get the issue of bail in there. Perhaps the federal government can offer money to the local jurisdictions to move away from cash bail into a more hybrid risk assessment program in the different jurisdictions, because as we know, money is a big part of it. But this particular organization has a unique opportunity to weigh in on public policy like this and to really flex its muscles in that direction. And I would encourage the organization to take that route.
Mr. Berry?
Thank you again so much for offering me the opportunity to come and speak with all of you and engage in this important conversation. It was really wonderful to participate with all my co-panelists. I appreciated many of your remarks, quite helpful to my own thinking. And I think what Bobby said is exactly right. This is an amazing organization. When Bianca started and talked about the long and important history that the organization has played, and particularly in this moment. I'm guessing many of you got involved in criminal law for the same reasons I did, because you saw injustices happening and you wanted to protect your community and you felt that you might be a better advocate for your community than other people. And this is a great opportunity to raise up the voice of Black prosecutors in that conversation and really help advance the reforms that we all have seen either not implemented or implemented with great success, but not broadly enough. You are an important part of that conversation. I guess that many of you are involved in that work in your local communities and in so many other ways. And I think the suggestion to be involved in the national conversation is a really wise one. If any of you are interested in working in California, my new organization, Prosecutors Alliance California, is focused on reform. We're a reform-oriented prosecutors organization, one of the first in the country, and we're really eager to talk with you about the work that we're doing. We want to be engaged with prosecutors of color as we talk about how to move our work forward and how to be the civil rights advocates that so many of us are, and the passion that burns in our hearts for that work and bringing that into our professional lives as well. So thank you again for the opportunity. It was a really great discussion, and I look forward to building with all of you.
Last but not least, Elise.
Yes, I want to echo the sentiments of my co-panelists. Thank you to the NBPA. I absolutely love this organization. It's been so supportive of me in my career. Thank you to Bianca Ford and Janae Thomas for inviting me on to the panel. And I guess my final thoughts would be, look, you know, bail reform can happen. I work in a jurisdiction where it works. It's not perfect. No system is going to be perfect. There's always going to be those aberrations where someone goes out and does something terrible, but that doesn't mean that we shouldn't work hard on reforming a system that we can see is not working and is broken, is discriminatory, and leaves a lot of lives in disarray for no reason. Because again, every defendant is presumed innocent before trial. And so for them to essentially spend so much time in jail when they may not even have to serve a day, being later acquitted, it's just fundamentally unfair. And so I would say for those of you who are not in jurisdictions that already have a working bail reform act or any kind of bail reform in your jurisdiction, get involved. Just like Mr. Berry said, in the Prosecutors Alliance, apply pressure. That seems to work. Lobby, join organizations. And as Bianca Ford can tell you, we have found that kind of like data-centered approaches where you put the numbers in people's faces and they can't refute it with anecdotes is very, very successful and impactful. So if you can show folks why this is costing them a lot of money, because that's the bottom line, then maybe they're going to listen to you and listen to the issue of bail reform a little bit differently if they're not interested in the 3 Bs. So there's lots of ways to get your point across. And I would say put a full front attack on the issue. Just make sure you apply pressure, don't give up, and volunteer. There are a lot of organizations in every jurisdiction.
Thank you all for attending this afternoon. As you see in the chat, there's going to be a follow-up survey. Please take the time to fill that out so we can plan our future programming. And last thing before you leave, please type GameStop into the chat. GameStop made a lot of millionaires last week, so we're going to give them a shout out. Thank you, everybody. Thank you to our panelists. Look forward to more from the Social Action Committee. And everybody have a great afternoon.
Have a good afternoon.